Good evening. I'm Allison Williams, representing the League of Women Voters of Bellingham and Whatcom County. Our co-hosts this evening are the Associated Students of Whatcom Community College, and joining me tonight to assist with questions is Caitlin Upson, Executive Vice President of the Associated Students of Whatcom Community College. The ASWCC is the student body of Whatcom Community College, and the executive board's purpose is to advocate for student voices and community, striving to create long-lasting support networks that will help current and future students. Founded in 1920, the League is a nonpartisan organization with more than 700 affiliates in all 50 states. Our goals are to encourage informed and active participation in government, increase an understanding of major public policy issues, and influence public policy through education and advocacy. The League never endorses candidates or political parties. Membership is open to all peoples age 16 and older, and we invite you to join. Tonight's forum is being broadcast on BTV and the City of Bellingham YouTube channel. Recordings of this program will be available on the League of Women Voters of Bellingham-Whatcom County website, LWVBWC.org, and at the City of Bellingham YouTube channel. The forum will be rebroadcast on BTV and 102.3 KMRE community radio up through Election Day, November 8th. No portion of this forum may be rebroadcast in part or in full without the written consent of the LWVBWC. Questions for this forum have been prepared in advance by the League and the students from Whatcom Community College with input from the public. The Cascadia Daily News, Linden Tribune, Salish Current, the Northern Light, and 102.3 KMRE Community Radio are our media partners. Tonight, we're hosting candidates for the Whatcom District Judge, Position 2. The Whatcom County District Court has 2 judges elected to 4-year terms. The court hears criminal, civil infraction, and miscellaneous cases in the county. Judges decide administrative and general court policy. They preside over cases and hearings in the court. The current salary for the office is $193,447. I would now like to introduce and welcome our candidates, Gordon Jenkins and Jonathan Rands.
Hello, thank you all.
Thanks, welcome. Here are the rules that will follow for tonight's forum. Each candidate will have 90 seconds to respond to each question. Then candidates will have a 1-minute closing statement. Each candidate has a challenge card that he can use once. The challenger has 30 seconds to state his challenge. The challenged candidate then has 30 seconds to respond. I'm going to ask candidates to speak in alphabetical order and then alter the order for the remaining questions. The timer displayed on the screen will count down your time, and the timer will be purple when you begin, then it turns to yellow when 15 seconds remain. When time is up, the timer turns red and you'll need to stop talking. If you continue to speak after the time limit, we may cut your microphone. Do either of you have any questions regarding these rules?
No.
Great.
No, thank you.
Okay, well, if our timer is ready, Caitlin is going to get us started with the opening question and the following 2 questions.
Ready.
How would you describe your relationship with your constituents, and what are your responsibilities to them?
So I bring the best and most public service oriented experience to this position. The district court judge owes a duty not only to public safety, but also to the very important rights and duties that are owed to all defendants coming through the district court. I am currently a senior deputy prosecutor, but I am also a former defense attorney who focused his practice on the representation of indigent defendants. I've handled cases ranging in severity from minor traffic offenses all the way to homicide, with everything else in between. I'm familiar with the needs of victims' rights and the impact of crime on our community and the needs of public safety, but I am also familiar with the intense weight of the criminal justice system on defendants and the degree to which substances and mental health concerns can drive those behaviors. To that end, I want to expand the use of therapeutic treatment courts within the district court system to try to improve and impact the cycle of crime and court appearances that we are seeing in our community. I want to improve the speed of the court process to benefit both defendants and victims, to make cases reach resolution in a reasonable time. In short, the district court should support a balanced, equitable, and holistic approach to the court system that respects all parties. And I have the kind of background that makes that possible. Thank you.
Caitlin, may I have the question again one more time, please?
Absolutely. How would you describe your relationship with your constituents, and what are your responsibilities to them?
Thank you. My responsibilities to my constituents, or essentially the actors within the court, are varied. Our district court, as we were exposed to at the introduction here, handles a variety of circumstances, but ultimately our district court is the people's court, and our district court is access to justice. While it does handle criminal misdemeanors, it also handles a wide range of other matters that people come before the court seeking justice for. Whether it be traffic tickets, whether it be a petition for an anti-harassment order or a no contact order, or whether you're presiding over small claims where participants are not lawyers, or whether you're presiding over a civil matter where participants are lawyers and the subject matter in dispute is up to $100,000. Everyone before the court is there for their own brand and own reasons for justice, even if it's as simple as a name change, so that you can access the rights and the rule of law that allow you for that name change or for that marriage that you're there for. I relate to my constituents by understanding the people that come before the court, because I have 20 years of experience in this court and almost every subject matter that the court entertains and deals with. In those 20 years, I've also experienced a wide range of other judicial cultures by being exposed to various county courts, and I aim to bring the best of every court to serve our county and to serve those seeking access to justice in the very best way possible, with restorative justice when possible, and accountability and access for all.
Thank you. All right, if we are ready to move on, I will ask the second question. Research shows that people of color, such as Black, Latino, or Indigenous, are more likely to serve time in the U.S. criminal justice facilities. How do you believe you can address bias in the courts?
I believe that question's to me. Thank you. By addressing bias in the courts, whether it be racial bias or systemic bias, the first step is education. The next step is using that education and always being aware, always looking around the corners to determine whether there's a blind spot that we don't see, whether there's a systemic issue that we're just unfamiliar with, because the people that are appearing before us with their unique issues, we have no experience with. But ultimately, the situation and the statistic that you have quoted is absolutely correct. There's a lot of reasons that people of color, BIPOC, LGBTQ come before the court more frequently than others, and that's because of the systemic biases that really begin at the line level, unfortunately, but also there is some systemic bias in terms of processing. And by the time they come before the court and with their access to justice, it is the judge's job from the top down to inspect, to look behind every corner, to look behind every procedure, and to just be painfully aware of what we are unaware of, if that makes sense. But you cannot do anything about it except be aware of it. And then when you are aware of it, implement systems that eliminate it and not necessarily fix it, because like I say, it starts at various levels. But if you are not aware of it, if you're not educating yourself to those things, then you're never going to find it and you're never going to fix it.
All right, thank you.
So the first thing to do is we always have to be acknowledging the existence of bias and acknowledging that we can't always see it in ourselves. To be always approaching it with a non-defensive approach of constantly challenging our own preconceived notions of what accountability means, of what may bring someone into the court, of what the way we view the world may be different from the way others approach things and may be different from the motivations that are driving them into something, and to constantly be challenging those notions in the court system. We always have to be remaining cognizant of the different lived experiences of those who are in front of us, and be open to a different worldview, be open to trying to assist people in a non-judgmental way and in a helpful and restorative way to address the issues before the court. We cannot ever be tied down into a belief that the way we view the world is the only way that is appropriate. And I think that has to be approached in every moment, in every part of the court system. There's no way to know when we are affecting bias in ourselves other than to continually be aware and to try and add new systems and be flexible to continue to expand the ability of the court to address these problems.
All right. If that is all, then I shall begin on question 3. Any lingering comments? All right. What are some alternatives to imposing bail, and when do you feel they are appropriate?
So we should always be looking first and foremost to be looking for alternatives to bail. So those should always be the first and most appropriate things we are looking to do, because the court rules specifically require the least restrictive means for release in cases. Things that we can look at alternative to bail are simply requiring people to more frequently check in with their attorney, or mandate more frequent phone calls or in-person check-ins, have family members who are willing to take some responsibility, monitor and come with people to court to make sure that they're staying up on their court dates. More extreme measures can include ankle monitors and things of that nature to try and keep people in contact with the court system. Probationary monitoring, trying to make sure that people aren't using substances or alcohol if their offenses are tied to those in some fashion. These are all, even limitations on people's ability to drive. All of these are things that should be looked at before we start looking at whether or not bail is necessary. Now, that's not to say that it isn't ever going to be used in the district court. There are situations where I think community safety is in play, and all other issues have failed, where people are continuing to violate the court order with new criminal violations of no contact order, new DUIs, things of that nature. But we should always be striving for other things first and only utilizing that as a last resort.
All right, thank you.
Thank you. I agree with Mr. Jenkins, and I agree with Mr. Jenkins because ultimately our rule of law and our Supreme Court in promulgating the district court rule orders district court judges and even superior court judges for that matter to always use bail as a last resort. That rule has come about because of one of the issues that we just talked about, systemic bias and bias in the system. And so at the district court level, since the most serious crimes we deal with are misdemeanors, we always first and foremost are looking to impose conditions of release which are designed to get a person back to court first and foremost, with bail as a last resort. The district court judge is really only limited by the creativity of the judge, but also by being aware of bias that might creep into that. For instance, the role of the judge is to set conditions that ensure first and foremost appearance. And so bail is never the first issue. The first issue is pretty typical conditions are to maintain contact with your lawyer. If you have a history of substance abuse or things of that nature, but more importantly, alcohol abuse, you can be subject to wearing an ankle monitor that monitors your galvanic skin response, and that does not necessarily mean trips to a probation department that you may not be able to access due to not being able to drive or being too far remote.
Thank you. Candidate Rands will stay with you for this next question. What is your opinion on programs that divert some of those accused or convicted of crimes into mental health facilities, addiction treatment programs, or other forms of supervision instead of jail or prison?
My opinion is that is the actual role of a district court. District courts are therapeutic, rehabilitative, and accountability courts. And so at every opportunity that a court can create a mental health court or a therapeutic court, or in my view of the world, also what I hope to create when I come to the bench upon being elected is a community court, a form of a therapeutic court. My opinion of them is they work. They are a form of restorative justice. They are a form of alternative sentencing. They are also a form of alternative sentencing that is very important, especially in our day and age right now, where we have very specific jail constraints, and the place for those that suffer from mental illness or those that suffer from mild or even severe alcohol or drug addiction is not a jail. It is a facility that is equipped to handle them, that has staff that is equipped to train them, perhaps medication available to help maintain stability and or detoxification, if that's what we're talking about. So by and large, these courts work, and these courts are really the backbone, if you will, of alternative sentencing, and that is the role of a district court. It's also the role of a district court judge to be creative as possible, to make sure that we utilize these facilities and these diversion programs to their fullest extent possible.
Thank you. Candidate Jenkins, your turn to answer the question.
Thank you. I'm of the belief that the more ways we have to try and get people assistance and address the issues that are underlying whatever behavior brought them to the courtroom in the first place, the better off we are. We should be looking at every type of diversion program we can possibly handle within the court system. We should be looking at diversion programs, substance abuse oriented courts, courts that deal with things like MRT and mental errors. Everything that we can to try and get at a root cause, I think, is to the benefit of defendants and the benefit of our community. Defendants in district court in particular are going to continue to be a part of our community. They're not going anywhere long term. Even if they were looking at a jail sentence, they're going to get out and they will be right back in exactly the same point they were before going in. So it is to their benefit and all of ours to try and address these underlying issues in a therapeutic and supportive fashion wherever we possibly can. But the more programs we have, the better, because what works for one person may not work for another. I've lived my support of this program. I'm the drug court prosecutor now in Superior Court. Right there, we work to help defendants try and deal with their issues of addiction and move forward in their lives. And that has the added benefit of having their cases dismissed at the end, so they're not lashed to a criminal conviction, which can have enormous impacts on housing and other things, which can further impact their likelihood of cycling back into the criminal justice system.
Thank you. Candidate Jenkins, we'll start with you again. It's been noted that the majority of current Whatcom County jail residents are being held pretrial, many of them for over a year. What actions would you take to speed the time to trial?
So one of the most important things, and this is something that I'm focused on in my campaign, is holding attorneys accountable to accomplish their goals, to accomplish meaningful movement in cases. Now, this is not to say that continuances are not appropriate in some cases. Defendants need to have a full-throated defense of their cases. The state needs to be able to present their case where appropriate. But cases should not be lagging, especially in the district court. So many of the people you're referencing tend to be on felonies, but people in district court in particular, where the maximum sentence would be a year, should not be languishing in custody for long periods of time. And to that end, continuance should not just be granted by agreement again and again and again. The court should be taking an active role in listening to why cases need to be continued, making sure that attorneys, if they're saying that something needs to be accomplished, checking in, seeing what progress is being made, and expecting and calling attorneys out to do the things that they say they do, in particular on behalf of the state. Gathering witnesses, gathering evidence, conducting the interviews that are necessary. And in district court, cases are relatively simple. They shouldn't be taking long periods of time to prepare. And it is entirely possible to get these out in a reasonable period of time to avoid defendants falling out of contact with their attorney, and also for the benefit of victims, people who deserve to have their cases heard in a reasonable time. Thank you.
Thank you. Candidate Rands, your answer?
Thank you. It is a district court judge, it's every judge's job actually, to ensure that a defendant's rights are respected and followed. And the right to a speedy trial when you're held in custody, that is 60 days from the date of arraignment or first appearance. Those are two separate things. However, from the date that you first appear, you have a right when you're in custody to 60 days. When you're out of custody, it's a 90-day period. The only reason to go beyond the speedy trial right of 60 or 90 days is for a finding of good cause. And what I'm experiencing or seeing daily right now, and I would agree with Mr. Jenkins, that ultimately we are seeing cases taking longer than that, much longer than that, for a variety of reasons. But before a case is continued, it is a district court's job to make sure that there is good reason, or what we call good cause, to continue the case. And by and large, that good cause, I've seen a reduction in it, or I've seen reasons that don't necessarily amount to it. And what that affects is the person's ability to get to trial before a timely manner. And so we really have to pay attention to the good cause, whether it is good cause, and ultimately not just move things along for the sake of agreement, because while the attorneys might agree on it, the defendant almost never agrees on it, especially if they're being held in custody. They want their day in court, and ultimately it is a district court's job to make sure that that happens and happens in a timely manner.
Okay, we'll go back to Caitlin for questions.
Thank you. Candidate Rands, we will start with you. Can you describe a circumstance where your personal beliefs conflicted with the law, and what did you do about it?
I describe a moment where my personal beliefs conflicted with the law, and what did I do about it? No, I can't. But what I can tell you is that it doesn't matter what my personal beliefs are in terms of conflict with the law. My role as a defense lawyer, or my role as an advocate, or even ultimately my role as a judge pro tem when I substitute for the last 4 years for judges, my personal beliefs really have no bearing on what the law conflict is. A judge's role or an advocate's role is to advocate or to rule within the law based upon what the law says and based upon what precedent requires us to do. What I can tell you about a situation that is hypothetical, where if a judge or a judge pro tem disagrees with perhaps the result that they have to get to, and they disagree with it for good reason, not necessarily a personal belief, but there are ways to write orders and judgments that encourage or complete a record, so that if others disagree with that, it makes it an appealable issue, or it makes it something that others can take notice of. But to substitute your personal opinion for the rule of law or for the precedent, there's no place in that.
Thank you, Candidate Rands. If you are done, we shall return to Candidate Jenkins.
Thank you. So I can think of some circumstances. So as a prosecutor, one of my jobs is charging cases. And the law of charging, the law of the ethics of charging require that I only charge a case if I am confident that I have sufficient evidence to prove that case. And that can be very difficult, especially in cases with victims in domestic violence and sexual assault circumstances. I have a belief that people do not report these sorts of offenses lightly or tend to lie about them. But if I do not have sufficient evidence, I am bound by law and by ethics not to charge them, however that may conflict with my personal beliefs on the issue. And as judge, you cannot allow your personal beliefs to soak into circumstances where you must be following the law, because that is where the bias that we've discussed at some lengths can seep in. It is when you start looking at, well, this circumstance, I want it to work out in that fashion. That is when what we want and where the unconscious bias that we might not even be aware of can take hold in the criminal justice system and result in inequitable outcomes, because I may feel that way in one case and not in another that is actually equally situated. The law is the guideline that we as judges are bound to follow. We can express our personal beliefs and our sympathy and be human and empathetic from the bench, but we must always return to the law.
Thank you, Candidate Jenkins. I will turn over to Allison.
Next question is, drug courts typically serve a small percent of those involved in drug-related crimes. What steps can a judge take to involve more of the addicted population? This goes to Candidate Jenkins.
Yes, so the judge, I think, has to collaborate with those in the other departments, with the prosecutor's office, with the defense, to try and work to expand the eligibility requirements and the space and funding for drug courts and other therapeutic courts. As prosecutor, I have actually worked to expand the Superior Court Drug Court here in Whatcom County. Since I've taken over, I have expanded the offenses that are able to be entered into drug court, whereas previously people were not allowed to make multiple attempts at drug court. They now are. There are also other sorts of broadening things that we've done to try and improve our census to get more people in who can benefit from these programs. Ultimately, the court cannot require prosecutors to give up their cases. Statutorily in Washington, drug courts require prosecutorial approval before those individuals can be entered into any sort of therapeutic court system. But I think the court can build confidence in those by running an effective court, by having good results and being focused on what the current understanding of drug courts are and producing good results. Because once that happens, it will incentivize the prosecutor and other parties to bring more people in, to be invested and believe in the system, to add more people into the program. So it's a chicken and egg, but having good results will help.
Thank you. Candidate Rands?
Can I have the question one more time, please? Thank you.
Yes, drug courts typically serve a small percent of those involved in drug-related crimes. What steps can a judge take to involve more of the addicted population?
Thank you for the repeat. A judge ultimately is in charge of the calendars and the types of courts that are created. So again, it's one of these scenarios where it starts from the top down, and the role of a judge ultimately is going to be creativity. I think creativity and how we can expand and include more people. But that creativity also requires cooperation. And ultimately what these types of courts are built upon and designed for is to divert people out. And when you do that, you also have to assess who are good candidates for that. And that takes some collaboration. It takes collaboration, I think, from the prosecutor's office. It takes collaboration from the probation officers or the mental health, or in this case, the drug therapists or the drug experts, if you will, or drug and alcohol experts. And leaning on them and leaning on those resources and figuring out a way of how things could be more expansive, but also making sure that we maintain the focus and people that are inappropriate candidates are screened out from that position. So I don't have any different opinion, if you will, as to my opponent. But what I can say is it's a position that would require and requires, I think, increased cooperation and encouraging both parties to cooperate to get to the root of the issue, and also to ensure that we have restorative justice and accountability.
Thank you. We have to move on to our last question of the evening before our closing statement. So Candidate Rands, our last question is, how do you distinguish yourself from your opponent?
Thank you. I distinguish myself from my opponent in a variety of different ways. First of all, I have 20 years in our district court, almost exclusively, not only in our district court, but other courts of surrounding counties, Whatcom, Skagit Island, San Juan County. In that 20 years, I have worked with the poorest population the court sees. I've also worked with those that are more affluent. There isn't really a participant in the court and their life or their lifestyle or their means that I have not worked with. I think I have a very good understanding of the general population that comes before that court. I have 4 years and growing of experience sitting as a judge pro tem, also known as a substitute judge at this level of court. So I have been doing the job for the last 4 years, if you will. I have the support of over 150 attorneys and local area judges, all that are aware of my work and are aware of my personality, my judicial temperament. But at the end of the day, I distinguish myself from my opponent based on experience. There isn't any subject matter in this court that I also haven't participated in. We tend to focus on criminal world, but ultimately in all the subject matters of the court, I have experience and extensive experience in it.
Thank you. Candidate Jenkins?
Thank you. So I also separate myself based on experience. I have, as a senior deputy prosecutor and a former public defense oriented attorney, I have handled court cases from both sides. I have dealt and understand the needs of victims. I have talked to victims and understand the issues that they go through. But I have also seen and experienced the issues and the weight of the criminal justice system on defendants and understand their needs and the importance of their rights and would respect all of those. I also have subject matter experience in a way that I don't believe that my opponent does. I've handled cases, as I said, ranging from minor traffic offenses to homicide. And I've also worked almost exclusively in a public-oriented type way. When I was a defense attorney, most of my clients were public defense, and all of my defendants are obviously, I work for the state now. So I'm familiar with the issues that comes from indigency on a regular basis. I'm familiar with issues of domestic violence, having worked extensively in those matters, and understand some of the counterintuitive things that can occur in domestic violence cases. The issues of safety that occur when victims go through the domestic violence cycle that bring them back to the court. Basically, I have a more broad-ranging and encompassing understanding of all of the issues that would be coming before the district court. I'm also the only candidate endorsed by current sitting members of the Whatcom County Superior Court. Thank you.
All right, we're going to move on to closing statements. You each have 1 minute. Candidate Jenkins, you can begin.
Thank you. I bring the most varied and beneficial experience, as I just said, to the district court judge. I have a current understanding of how therapeutic court systems work. And as we've discussed at length, the district court is a therapeutic system working directly in drug court. I understand how to operate a therapeutic court system, how to support and still hold accountable. As a prosecutor and a former defense attorney, I understand both sides of the court, understand how to hold both sides accountable to do what is necessary for a truly just court system. I understand all of the types of legal and factual issues that will be appearing before the court and can carefully administer them. I'm supported by a broad range of members of our community, from elected officials to treatment providers, to law enforcement, to social services workers, to the judges who are in our Superior Court now. Thank you all very much for your time, and I ask for your support as well.
Candidate Rands, your closing statement, please.
Thank you. My experience in the district court far surpasses that of my opponent. I've been practicing law in our district court for 20 years, and in the last 4 years gained experience on the bench as a substitute judge, a judge pro tem. I'm supported by over 150 area judges and lawyers who have all endorsed me and know my work and know the quality of my work. I know this court. I also know how to make it better for all of us. I have a well thought out plan to develop a community court and a resource center that will serve everyone. I'm a longstanding member of our Whatcom County community. I'm well aware of our concerns of crime, mental health, addiction, and I know these issues have to be dealt with, but they must be dealt with fairly, intelligently, and without bias or blind spots. This is why Labor and Lummi Business Council support me. As a nonpartisan judicial candidate, it is essential to have a bipartisan support. Anything else permits a weaponized judiciary to take hold. I'm proud of the fact I'm the only candidate endorsed by both the 42nd District Democrats and the Whatcom County Republicans. I intend to be a judge who is fair for everyone, to everyone, and ensures access to justice for everyone. I am Jonathan Rands. Thank you.
Thank you. On behalf of the Associated Students of Whatcom Community College and the League of Women Voters, I thank the candidates for being here today and for their interest in running in public office. Voters can find more information about the candidates online at vote411.org and in your voter pamphlet. Ballots will be mailed October 19th this year. Your ballot must be postmarked or in a ballot drop box before 8 p.m. on November 8th. Please remember to sign the ballot envelope, and if mailing by postal service, we recommend that you mail early. Thank you very much for coming this evening.